Welcome to the deep dive. Today, we're tackling a really common and honestly pretty stressful question in business and law. How can you tell quickly if that official-looking document you signed, the one with all the signatures, is actually a legally binding contract? Or is it just, well,
Hey,
paper? A lot of professional relationships kick off with these master service agreements, tender documents. Things look solid. But then later, someone finds out it just doesn't have the legal teeth needed if things go wrong. So the problem we're diving into is understanding consideration, specifically this idea of mutuality of obligation. It's what separates a real promise from, well, an illusion.
right. And to help you cut through that complexity, we need a clear path. First, we've got to establish what genuine reciprocal consideration actually means. It's the bedrock, really. Then we'll apply this important doctrine, the illusory promise doctrine. We'll do that by dissecting a key federal case, that firefighting fiasco, Ridge Runner Forestry v. Veneman, and we'll focus laser-like on what each party actually promised or didn't promise.
Okay, let's unpack that. Before illusory promises, let's hit the absolute foundation: consideration and mutuality. For a promise in a contract to be enforceable, what's the fundamental requirement? What do parties absolutely have to exchange?
Okay, the general rule is pretty clear. A valid contract needs consideration. And consideration means there has to be a bargain for exchange where each party incurs some kind of legal detriment.
Hold on, legal detriment. That sounds a bit legalese. Can we simplify that? Does it just mean giving something up?
Yeah.
Or limited my future choices?
That's it, exactly. Limiting your choices. It's about giving up some legal freedom you otherwise have. If you promise to sell your car, you're giving up the right to keep it. That's your detriment. My detriment is giving up the money. But, and this is key, if your promise is worded so you could basically walk away without consequence, if your future action is still entirely up to you, then you haven't actually incurred that legal detriment. Your promise is, well, it's illusory. And that brings us neatly to the formal rule about illusory promises. The courts, like in Torcello v. United States, define it as words that look like a promise but actually promise nothing. They don't put any real limit on the promiser's freedom. It's like they said nothing at all. It's fundamental contract law. You can't base a contract on one illusory promise, let alone two.
Okay, this is where it gets really interesting, I think. Let's test this rule right away with a big real-world fight. Ridge Runner Forestry v. Veneman. Ridge Runner, they provided wildfire fighting stuff, right? Equipment, crews. They spent time, money, signed this agreement with the government, thought they had a deal, but then they kept getting passed over for jobs. So they sued, claimed the government breached this implied duty of good faith and fair dealing. Right. Let's analyze Ridge Runner Forestry v. Veneman. First, what are the legally dispositive facts? What did this agreement actually say?
Okay, the key facts. Ridge Runner responded to what's called an RFQ, a request for quotations, from the Forest Service. They signed this Pacific Northwest Interagency Engine Tender Agreement. Sounds official. But the killer facts were buried in the clauses, actually highlighted in bold. Three crucial ones. First, the agreement specifically said the award did not preclude the government from using any other resources, local, federal, whoever. Second, it emphasized the award did not guarantee any need for the equipment or that any orders would ever be placed. And the real kicker for Ridge Runner, they were only required to provide equipment to the extent the contractor is willing and able at the time of order.
Okay. And what was the core legal issue then? They wanted to sue for breach, obviously, but what was the first hurdle, the legal question they had to clear just to get the case heard?
The absolute threshold issue was, did that tender agreement even create a binding contract at all? This was fundamental for the Board of Contract Appeals jurisdiction. Ridge Runner's whole claim rested on this implied duty of good faith. But, if there's no contract...
Then there's no duty to breach?
Exactly. The whole case collapses right there.
So what rule did the court apply to figure out if this was a real contract or not? Did they compare it to anything?
They went straight to the fundamental rule, mutuality of obligation, for its consideration from both sides. And yeah, they contrasted it specifically with cases involving true requirements contracts. They mentioned the Ace Federal case. In a real requirements contract, the buyers say, the government promises to buy all of its needs for a specific thing from that seller. Or they have to get a formal waiver. See, that promise of exclusivity limits the government's freedom. That's real consideration. But when the court applied that standard, that illusory promise test, to Ridge Runner, well, both sides failed completely.
Okay, let's get into the court's analysis. Why exactly were both promises, the government's and Ridge Runner's, seen as illusory?
Right, it failed on both counts. Let's take the government first. Their promise was pure illusion because of those two clauses we mentioned. The one saying they could use anyone else, and the one saying they didn't guarantee any orders. This meant the government kept total, absolute discretion. They hadn't limited their future actions one bit. They basically promised to think about using Ridge Runner, maybe. That's not a binding commitment. Now, Ridge Runner's side, their promise was just as weak. That willing and able clause, fatal. They only had to show up if they felt like it, essentially. If they were willing and able when the call came. Maybe they got a better offer that day. Maybe the crew was tired. Doesn't matter. They could decline without being in breach. So by keeping that complete out, Ridge Runner didn't incur any real legal detriment either. No skin in the game, you could say. Since neither side was truly bound, that essential bargain for exchange just wasn't there.
And the conclusion, what was the final ruling?
The court upheld the earlier decision. No contract was formed. Period. Those tender agreements. Nothing more than illusory promises from both sides, which meant Ridge Runner's claim about breaching an implied duty. Well, it had no legal basis because there was no contract to attach that duty to in the first place.
Okay, to really make this stick for you, the listener, let's imagine something more visceral. Picture a huge, scary flood hitting your pan, massive cleanup needed. The city signs an emergency services agreement with a big cleanup company. But the agreement says the company only deploys its special drying teams if the contractor is willing and able when the city calls, and the city's promise. Well, if they decide they need a specialized team, they might call this company. But they're also totally free to use anyone else volunteers, another company, whoever, and they don't even have to tell the first contractor.
Yeah, that hypothetical really drives it home. Why would anyone sign that? And more importantly for us, why does the law say it's basically worthless?
So what jumps out at you in that flood scenario? It feels urgent, looks like a commitment, but why does it fail the mutuality test just like Ridge Runner?
It connects right back to that concept of legal detriment, or the lack of it. Both sides kept total, unchecked freedom. The cleanup company. They could say, sorry, not able today, got a better gig across town. No penalty. And the city, because they reserve the right to use anyone, could just ignore the contractor if a cheaper or faster option popped up. Again, no penalty. The law looks straight past the title agreement and asks, did you actually limit your freedom? Did you bind yourself? In Ridge Runner, and in our flood example, the answer is a clear no. That willing and able for the contractor and the use anyone for the government. Zero binding obligation. And that's a critical distinction for anyone dealing with contracts. Signed doesn't always mean enforceable. If that real mutual commitment isn't there, the whole thing can unravel. Okay, so what's the practical takeaway for you when you're faced with a document like this? We can boil this down into a kind of diagnostic checklist. 4 steps for spotting consideration issues. Step 1, check the promissory form. First, just look at the words. Are they actually words of promise or commitment? Does it say, I will do X? Or is it more like, I hope to, I might consider? That vague, hopeful language, sometimes called precatory language, often fails right there. Step 2, check for constraint. This is the big one, the real test. Does the language put any real enforceable limit on the promisor's future freedom? Look carefully for escape hatches, clauses like willing and able, or the right to cancel just because you feel like it. If you can get out of performing without consequence, there's probably no real constraint and likely no consideration. So the promise is illusory. Step 3, analyze reciprocity. Okay, assuming there's some apparent promise, are they mutual? Did both sides genuinely limit their freedom? Did both incur a legal detriment? Remember, if even one party's promise is illusory, the whole contract usually fails for lack of consideration, especially like in Ridge Runner, if both are illusory. Step 4, check for exceptions. Or you may be looking at a true requirements or output contract. Is one party promising exclusivity? Like, I'll buy all my widgets from you. Or is there a guaranteed no-one purchase? Those kinds of promises do limit freedom and usually provide good consideration. But if you don't see that kind of exclusivity or minimum commitment, be very, very suspicious of clauses that let one side keep all their options open.
That's a really helpful framework, that 4-step check. It gives us a clear way to diagnose these things. The big lesson here seems to be, well, you need actual skin in the game in contract law. The language has to show real commitment. You can't promise something with one hand while keeping the absolute right to take it back with the other.
Precisely. It's about genuine commitment. If you end up in court, you need to point to something concrete that you gave up, some freedom you restricted. If the agreement is just full of ways for you to avoid performing, it's probably not worth the paper it's printed on.
Okay, a final provocative thought for you, the listener, to chew on. What if Ridge Runner's agreement had one small change? What if they agreed to pay just a tiny penalty, say $100, every single time they declined a Forest Service request when they actually were able to respond? Would that small, specific financial consequence have been enough? Enough detriment to make their promise real, satisfy consideration, and save the contract from being illusory? Something to think about next time you review an agreement. Thank you for joining us for this deep dive into consideration, mutuality, and what makes a promise truly binding or just an illusion.